everyone, and welcome to Let's Talk web conference. Thank you everybody and the attendees as well for joining in. First, let me introduce myself. My name is Bharti. I'll be hosting this web conference today. The topic is ADR, Alternative Dispute Resolution, is a new thread in the post-pandemic time. Just a little bit of housekeeping before we get started to everyone who is joining in. If at any point of time you have any questions, please type them in the question box in the control panel. I'll try to bring them up during the presentation, but if not, we'll make sure to save some time for the questions at the end of it. I'm really glad to welcome our speakers today. Our first speaker is Ms. Justina Aliva, partner at Chapter from Nigeria. Our second speaker is Mr. Syed Majeure, head of contracts at Larsen & Toubro, Dubai. Our next speaker on the panel is Mr. Karim El Hilaili, who is an IP and law tech expert from Dubai. And our final speaker, who is also moderating the session today, is Mr. Divyam Agrawal, partner at J. Sagar Associates from India. So now, without any further ado, we'll turn the time over to Mr. Agrawal. The stage is all yours.
Good evening, everyone, and good afternoon to some folks from the West. Today's theme for discussion is a very interesting amalgam of two commercial, or I would say legal topics, which have been in vogue because of COVID. First is ADR and its digital evolution, and second is force majeure. Our discussion today will first revolve around ADR and its effectiveness, followed by a round of discussion on how during and post-pandemic there has been a digital evolution of ADR. This will in fact set the tone for the last topic, that is force majeure, and how COVID has reshaped the disputes of future. To pave the way for further discussion, let me first briefly allude to the concept of ADR. The speedy justice system is one of the fundamental requirements of any civilized society. Keeping that in mind, when the courts were overburdened with cases and the average time required for deciding a dispute increased substantially, steps were taken to decrease the burden of the courts. Alternate dispute resolution came up as a future of traditional dispute resolution mechanism. ADR, as it's famously called, mainly denotes a wide range of dispute resolution process that act as a means of disagreeing parties to come to an agreement without using litigation as the adjudication process. Arbitration and mediation are the most integral part of ADR. In fact, arbitration has globally become the most favored mode of dispute resolution mechanism. At this stage, let me invite Justina to explain different ADR mechanism with a specific concentration on the most popular ones, that is arbitration and mediation.
Thank you very much, Divyam. I hope everyone can hear me. Okay. All right, so from the discussion by Divyam, ADR, or alternative dispute resolution, as the name suggests, is an alternative to litigation. And from time immemorial, from our forefathers, this concept of justice has been with us. And they passed it on to us, onto this generation. And so we have the traditional institutions as well as elders settling disputes without resort to court. And why is this popular, or why is this so? It's because man by nature wants to make up and find solace in his relationships, whether it is business, whether it is family, whether it is religious, whatever it is, man does not want to stay away from one another for too long. So when disputes arise, they want to settle it immediately. They want to resolve issues immediately. And so they resort to means of settling these disputes. And there are alternatives, so many alternatives. Well, like Divyam said, we're going to concentrate on mediation and arbitration, which are the most popular. But without mentioning others, I will quickly say that there are other means, and it could be a mixture of arbitration and mediation, which is made up. There's negotiation, there's mini trial, there's also what you call a mixture of some of these mechanisms together. What is the end result? The end result is that they just want a peaceful way of resolving their disputes amicably without any rancor, so that businesses can continue, because with litigation, sometimes you form permanent enmity amongst yourself. But for those who are in the commercial business, you would want a situation where you can foster the business after resolution of your disputes. And so it has come in handy, it's getting very popular, and with the pandemic, it's even increasing the more. So I think that mediation, arbitration is something that is going to grow bigger than what it is now in the future. So what does this entail? For both of them, really, it is a way of getting someone you call the mediator or an arbitrator to preside over your proceedings and to foster a settlement in the case of mediation. And in the case of arbitration, it's more formal in the sense that that person or persons that you would have appointed as arbitrator would listen to you, take evidence, and then come up with a decision, which is called an award or judgment that is enforceable. So I think I can pause there. This has set the background for arbitration and mediation for the discussions that we will carry on as we proceed. Thank you.
Thank you, Justina. I think that's you very well put the different form of mediation, form of ADR we have, and as you rightly provided for, that mediation is to foster settlement, and how arbitration has this nuanced mechanism of resolving disputes. I would also want to seek your views as to what are the advantages of ADR over litigation, because our audience here, apart from the fact that there are various mechanisms, how ADR is beneficial over traditional litigation. Maybe it'll be good to seek your views from your local jurisdiction.
Okay, from my local jurisdiction here, in fact, just like the name suggests, ADR, alternative dispute resolution, it lacks any striking formality, unlike the courts where you have a proper court place and people are robed, or lawyers are robed, wearing wigs, and going to defend or prosecute a matter. In the case of arbitration and mediation, you don't find anybody wearing any wigs or robing to go. In fact, they're seated on a table in a room that is provided as if it were a conference. So that alone sets the tone that these people are here to discuss and to foster an amicable settlement. So that, for me, is very striking in the sense that you already have people who have disputes coming together, sitting on a round table as though they were friends already. So the atmosphere is friendly. There's no tension about it. Now, mediation and arbitration is not time consuming. It's faster, it's cheaper, and efficient. There are no technicalities. And I will give you an example of one experience I had while I was in the bank. You know, we had a matter when I was serving, because we have a mandatory service here in Nigeria. So I served with a bank and the legal department, and I was given a case file to study. And what am I supposed to do? I'm supposed to review the case and then follow up with the solicitor that is handling the matter, the advocate that is handling the matter, for updates. So 1 year, to cut the story short, 1 year after, it suffered so many adjournments. The case did not proceed. And I left that bank. I went back to the Ministry of Justice. I got employed in the Ministry of Justice, spent 1.5 years there, came back to the bank because they employed me. They found my services good, and then they asked me to come back. I came back, and that case suffered so many adjournments, it would proceed. 2 judges died, and the case had to start de novo from the beginning. So about 7 years was wasted. And then when I now became the company secretary and chief legal counsel, I was the same person who resolved the matter out of court. So I kept wondering until today. I wonder that what happened? Why didn't they use this alternative method to settle the matter that I came to settle about 8 years after, when 2 judges and even some of the litigants died? You know, so that would have been avoided because it cost them money. At the end, the company was wound up because they couldn't proceed with the business. So I think it's not good enough. And that is why arbitration or mediation is becoming popular, and people who are in the commercial or business sector will prefer to use these alternative methods. However, there are also disadvantages, but I will mention them in a short while. Let me just talk a little more on the advantages. So it's always a win-win situation. You don't have anybody say that I have lost the case or I have won the case, because it's a give and take. And the parties own the process as it were, especially in mediation, because they are the ones who would tell their story and how they want to foster. So you hear things like, I still want to do business with Diviam, but Diviam is slow in his supplies. If only he would speed up in supplying me at the time that I wanted so that I don't lose customers. I like the way we do business. So it's a win-win situation. It's good. It keeps business secret, unlike the open court, where it is a public place and anybody can come in and listen. There's no restriction. But for mediation and arbitration, it's confidential, and only those you permit to come in will come in. You also have flexibility. You have flexibility in that process, and you are in an atmosphere where there's general understanding. People are communicating. There's no aggression. Let me put it that way. There's no aggression. And so with all of this, it is gaining more ground, especially now that there's business across borders. You know, for instance, in Nigeria now, we have the African continental free trade area. And I imagine that there will be a lot of disputes because we'll be trading. So if you wait until you go to court to resolve your disputes, you will not move, you will not do any business. But if you latch on the ADR mechanisms, then you will move, you will do a lot across borders. So I think that there's a lot to gain using mediation or arbitration or alternative dispute resolutions to resolve matters or disputes. However, you know, there's a disadvantage. You know, sometimes since the decision is at the discretion of the parties, some parties may not want to settle, which will set you back, and then you will begin a court process. Also, the absence of formality makes the procedure, you know, it doesn't have any legal backing. So you just, especially for mediation, you just keep on at it as the parties direct you, because you are there just to guide and help them to reach a settlement. So with that, I think that I will pause here and let Diviam carry on with questioning others. Thank you very much.
Thank you. That's actually, yeah. So I think this was a very important observations you have made. And in fact, most of them are true for every jurisdiction. It's not just limited to yours. Taking an example closer to home, we have around 40 million cases pending in Indian judiciary. So that can give you the number of cases which are pending, and backlog is increasing. COVID has also added misery. I agree. I think one of the most important points you made was to do with posturing. that how the setup is created to help parties arrive at a settlement. The environment, the informal nature of it, the conference like setup, that's actually a very, very interesting point you have made. Obviously, all the other points are equally important, but I thought that posturing is a very relevant aspect there, unlike any other legal judicial system, which is very confined to dogmatic framework created centuries ago. And I agree that the advantages of ADR over litigation are quite many. In fact, you alluded to privacy and confidentiality, considering the fact that open courts are there and everybody can visit those. High stake commercial disputes involving price sensitive information. For those matters, no client or no party would be interested in disclosing that information in open court. I mean, we all have seen in open courts parties requesting for giving information in sealed envelope. Thankfully, in arbitration, the entire proceeding is sealed unless parties agree otherwise. Also, there is this inherent flexibility in the mechanism where you can and you are the parties are in complete control, which we all in common law jurisdiction understand as party autonomy. There is this party autonomy which allows, and in fact that's like the heart of ADR, that allows parties to set up the mechanism. They can determine how they would want to proceed, what kind of a process they want to follow, leading evidence. There are simplified rules. Discovery, there is a simplified rules. Party can just literally lay the land for themselves and come up with a solution there. And obviously the finality is also extremely important. Closer to home, I can say that once an arbitral award is passed, the judicial intervention is bare minimum. There is courts usually do not interfere in arbitral awards passed with reasoning. They cannot sit and do a second round of it. It's very limited grounds like public policy and if there is any kind of an infirmity which is apparent on the record. So it's very limited judicial intervention, which again makes it a very attractive proposition. So thank you, Justina, for that. Wonderfully capturing the essence of ADR, especially arbitration and mediation. As you rightly pointed out, those advantages, and in fact even those disadvantages, I agree they are there. But we must remember that ADR is the creation of agreement. To accurately apprise the impact of COVID on ADR, it is a prerequisite to consider its impact on the underlying contracts. And we all know that the construction and the real estate sector being one of the worst hit industries due to COVID, and has even seen much upheaval. And for that, Saeed here has been in the middle of action. Saeed, I'd like to bring you to this discussion and ask you, how has COVID impacted the performance of construction contracts or the ongoing contracts in the construction sector? If you can throw some light there.
Yeah, thank you, Deviam. Actually, as we all know, the coronavirus started in December 2019. Then in March 2020, it was declared as by WHO as a pandemic. So after that, the governments, they have implemented across the globe restrictive measures in order to curb the spread of the virus. So the pandemic, along with its associated restrictive measures, they have directly impacted the performance of the contracts in all sectors, actually. But if we go to the construction sector, as you mentioned, as you rightly said, it has been hit a lot, actually, and it is the first impact that was the spread of the virus along the sites and the labor camps, where it was very difficult to strictly implement the health and safety measures in such crowded places. And this outbreak, actually, it led in many cases to temporarily suspension of works at sites. And the suspension will not be lifted unless all the infected people are isolated, the site and the camp are sterilized, and all unaffected workers pass the incubation period, which is more than 14 days. At that time, it was 28 days. So the first impact was definitely the suspension of work sites at all the projects due to the lockdown from one case side and due to the spread of the virus among the workers, especially in the crowded places, which the labor camps were the source for that. The second impact was also the delays and disruptions that we faced and encountered on the work progress due to the delayed or canceled deliveries of imported materials and equipment, which are usually supplied from the lockdown countries, especially Europe. We are talking about Europe, China, and India. And this has affected the performance of the contracts tremendously, actually, and it has created a lot of delays and disruptions. The third impact is also delays and disruptions that are caused by the shortage of labor in the country, in UAE as an example, or in Saudi, and in Egypt, we were having a lot of projects there, and we were having difficulty to find enough labor because they are expat labor that are coming also from abroad, and it happened due to the suspension of the flights and the visas and the closure of the borders of those cities. The fourth impact is disruptions that are caused also by the extra health and safety resilience measures. So on top of all the health and safety measures that we usually have in construction, everybody, the client and the municipalities, as well as all the government authorities, they have added extra health and safety resilient measures, which were very stringent and onerous on the contractors also. And this has actually been implemented in the accommodation camps and the transportation vehicles and at sites, which includes regular disinfection and sanitization. You have to do social distancing, wearing gloves and masks. We have to do temperature checks and isolation of the infected workers. So all those measures, actually, they have impacted a lot the performance and disrupted the work progress. On top of that, some of the clients, and most of them, they were asking to do frequent PCRs to all the workers who need to enter the site. So this have added a lot to the cost of the contractors as well as to the subcontractors. Now, from my experience, I have personally experienced the impact of COVID-19 on the performance of contracts for two mega projects, one in UAE and the other is in Saudi Arabia, where both of the scope consists of engineering, procurement, and construction works. So from what I've encountered on those contracts, I can say that it is very crucial to be cautious of how contracts are drafted. This is very important to ensure that contractors are relieved from the onerous impact of COVID-19. So in both the contracts, even though both the contracts were having similar nature of works, which is industrial projects, and both of them are contracts with governmental companies as the clients, one of the clients, he granted us extension of time relief due to COVID-19 and restrictive measures. However, the other is still an ongoing dispute, and it's under negotiation stage, which is likely to be referred, in my view, to arbitration. Thank you, Devian.
Thank you, Saeed. And I think it's very fascinating the way you described the on-ground position. And normally, lawyers on the other side, they may not have that visibility, and it's great to have that perspective from the client's end. And in fact, I agree that the drafting of contracts is an essential topic. In fact, our endeavor today would be also to cover that aspect insofar as the issue of force majeure is concerned. But just before that, let me move to our second topic of the day, which is the post-pandemic transformation and digital evolution of ADR. We, as Saeed rightly pointed out, that coronavirus has drastically impacted communities worldwide. In fact, the crisis resulted in surge of disputes which required urgent intervention. COVID-19 presented challenges not just for contractual performance, but for contract enforcement as well. Though courts were initially reluctant, necessity enjoined them to adapt. The country-wide technological update that would have taken years was completed within a few months. Karim, now I would like to bring you to this discussion and ask you, how have courts in the UAE and Saudi Arabia dealt with the issues thrown up by COVID? Please give an overview on the current progress on the ecosystem for digital litigation in the region.
Thank you, Divyam. Indeed, like you said, the COVID accelerated. I wouldn't say it pushed, but it accelerated. Remember, I mean, countries like UAE and Saudi, they have invested very much in IT infrastructure over the years. One of them was definitely the litigation system and the accelerated litigation system and electronic system, etc. And what COVID did, actually, I mean, all this were there, the infrastructure was there, the application was there, the technology stack was there. It was waiting for an event to kick off this. And with COVID, and exactly like Saeed mentioned, due to the pandemic, resulted government restrictions across the board. One of them are the curfews and the shutdowns, and courts are, not operating as normal. Notary public is not operating as normal. Government agencies are not operating as normal. So with the infrastructure, with the proper infrastructure being in place, and so the government, and believe me, the government in the UAE and Saudi are very much in technology for a while now. So the infrastructure being there and the mindset being there, so the transformation was kind of waiting to happen. The pandemic just kicked it off, and then so people were able to resume notification online, receiving court notifications online. All of a sudden, you're receiving an SMS of a court date or a hearing or an expert session online with a Zoom link. Okay, Notary Public, you don't have to go there physically and sign. Digital signature was enabled all of a sudden. The laws, the idea, and the good thing here in the region is that the ecosystem, the legal legislative ecosystem was there. The infrastructure was there, the mindset was there. It was a matter of switch on, okay, to move or to transform from the on ground or on-prem to the cloud, be it, or whatever transformation is required for that entity. But it was a matter of switch. Of course, there were a lot of raising awareness, training, but it was there. And that was lucky for some countries like the UAE and Saudi. Others didn't have the infrastructure in place, so they are catching up now. And this was key, okay? Because and all of a sudden you found what Justina was referring to, her, like, stagnant judicial system cannot accommodate all these sort of disputes. You have another window, another platform that you can actually move on, to, and actually resume business as usual. Okay, on the contrary, you found it more expedited, more accelerated, more prompt. I personally have attended the tens of hearings online, and the expert, the court expert, who is as I call a classical court expert, some of them were very impressive on managing that on a Zoom or a meeting or whatever the platform is. But you feel there was training before this somehow, and it was only a matter of riding it. So that was important on that front, and I posed there because that is mainly the topic here, the how well those countries were set for this leap of digital litigation, digital disputing, digital resolution, digital ADR somehow. I mean, in arbitration mediation, we were very much accustomed to, Zoom meetings prior to the pandemic or COVID in general. But litigation, court system, that was a precedent, and I think it went very well. And now it's evolving into a more, digitally transformative environment for business and across board. Thank you.
Thank you, Kareem. That's a very relevant observation by you that two things that helped UAE and Saudi sailed was the infrastructure and the mindset. Uh, that's a very good combination there. Most of the jurisdictions either don't have the infrastructure or don't have the mindset. Now, but that's exactly which brings us to the next topic, that how arbitration this has from, it's not restricted to any boundary, any territorial jurisdiction, and how it has evolved across the globe. And putting it that from Socratic city states till date, arbitration has surely come a long way. In fact, it has dethroned litigation both in terms of efficacy and adaptability. I would say that, and I will briefly discuss what is the how arbitration has technologically adapted itself and how it has become the most favored source of dispute resolution mechanism. One of the fundamental strengths of arbitration is its efficiency. In fact, due to its inherent efficiency, uh, the top three arbitral institutions in the world, ICC, SIAC, and HKIC, all reported record-breaking numbers in 2020 when the litigations across the world were suffering. And it's the timelines in arbitration, that's one. And we briefly, Justina also alluded to during our discussion in ADR, that timelines is very strict in arbitration. Most jurisdictions are very clear. You have to complete, there is a set process prescribed. There is, you literally have a walkthrough, and 1 or 2 years is the time period you usually look at whenever you are, no matter how technical the dispute is. And as I pointed out, party autonomy ensures that there is freedom to conduct the arbitral proceeding in any mode and manner, be it physical or virtual. More and in fact, more and more people are opting for the virtual mode in arbitration. As Kareem rightly pointed out, that Zoom meetings was quite a normal affair when it comes to arbitral proceedings, unlike litigation, which was like first time introduced that. We all agree that remote hearings are the inevitable future. Arbitration already helped parties save cost in terms of time and money, and with remote hearings, parties from multiple jurisdictions may participate without worrying about travel, accommodation, and in fact the newfound danger of physical contact. I was part of, during COVID, in fact I was part of this arbitration where the arbitral tribunal was seated out of London. My client was based out of Dubai. The opposite side was based out of Cayman Islands. And we as the councils were from India, and the opposite side's councils were sitting in Singapore. All of us joined together in one forum over a Zoom call and had a live transcription done. The process was seamless. We had no carbon footprint. Otherwise, we all would have converged in one jurisdiction, would have wasted 2 or 3 days, 5 days. We managed the entire process seamlessly on a Zoom platform. There was breakout rooms available for the tribunal to confer, parties to confer separately. So there are inherent benefits, and when arbitration, in my view, when it meets the digital evolution which we all are seeing, then I feel that it is in fact the most important thing possible. In fact, I will just give one statistics that Whiten case, together with Queen Mary University, conducted a survey on arbitration practices in 2021, and their results were that 76% respondents said that they use virtual hearing platforms, up from 47% in 2018. Only 5% said that they have never used video conferencing for arbitration, and 80% respondents said that they would opt for a virtual hearing rather than postponing a physical hearing altogether. So it's a clear thing that there is a worldwide boom in arbitration. As I said, path-breaking numbers are there. This, in fact, brings us to a very interesting topic, which is somewhat related to arbitration and dispute resolution mechanism. There is a new, I would say, baby on the block, which is called as the online dispute resolution, popularly called as the ODR. And that has blossomed over the past couple of years. In fact, COVID has given it a right impetus it required. And therefore, I request Justina to throw some light on how pandemic has promoted ODR, or online dispute resolution.
Thank you, Divya. Yes, you are right. ODR is now very popular, even though it evolved from settlement of e-commerce disputes. But with the pandemic, we saw it rising, and a lot of parties keying into online. And in fact, some of the institutions had to facilitate training on how to use some of these features like the Zoom and Teams, so people can get familiar with it and be able to key into it. Now, ODR, as known as online dispute resolution, is something that I think has come to stay. And why am I saying this? I'm saying this because during the pandemic, particularly 2020, quarantine, lockdowns, you couldn't move anywhere, and yet disputes were piling, and people had to find a way. And so that gave rise to leveraging technology. For the developing economies, they already had the infrastructure in place, and it was just a matter of keying into it and leveraging it on a large scale. Now, for those of us in developing economies, we don't have that infrastructure. But however, the little that we have, we leverage on it, and there were virtual hearings. Even courts had virtual hearings they could take to listen to motions and deliver judgments. Now, back to ODR, which is the online dispute resolution. You had a lot of people keying into it, especially in the area of mediation. And parties were taught how to use the Zoom features. So in there, you have breakout rooms. It is just the physical interaction that is missing, because everything that you can do physically, you could do it using those platforms. And the two popular platforms at the time, and which still is today, is Zoom and Teams. So that became very, very popular, and till today, people are keying into it and they're using it, and it has come to stay. Now, are they efficient? Yes, they are efficient. There's no commitment in that. Your cost is reduced, as explained by Divian, because the cost of you traveling to whatever jurisdiction, the tickets you will worry about, even is safe, because with the pandemic, you are not afraid, or you fear that after interacting with someone for some time, maybe you would contract COVID. So it gave a sense of trust, and it made people happy wherever they were, because in the comfort of your house or in your office, you could participate fully. So disputes were being resolved, and it was fast, because they also understood the fact that there could be Zoom fatigue. So you would ensure that you settle whatever disputes you had on time. And if you had to adjourn or come back, then it will just be a matter of maybe the next day or the next date that you fix for that to be heard. Although there were fears of how secured were these platforms, you know, the issues of privacy and security. And, you know, sometimes people can just barge into your meetings without you knowing, and they can get information and data. But by and large, most of the platforms provided security for their platforms, and then the ones the parties or institutions too will provide for themselves. So it wasn't bad at all to move on to that quickly, because people latched on it and they were getting results and they were happy with what was happening. From there, you know, I talked about the features that the Zoom had. You could share your screen, you could use whiteboard. There was nothing that you couldn't use. The only thing missing is that because we are human, we like to interact. That was not there. And things like eye contact that you would like to see, which is very, very good in mediation, and gestures, body language, and the tone of voice, all of those synchronicity were not there, because the human being likes to see when they're talking and wants to see the reactions. But I mean, there's enough gestures using Zoom or Teams. You could see at least up to the shoulders. We're seeing ourselves as it were now. It looks like we're sitting in one room. I can see all of you. You can see, and you can see the gestures that I'm making. So I think that ODR is something that is going to continue for some time, and it can only be promoted. And because of that, I know that in Africa here, because COVID forced us, let me put it that way, forced us to learn about technology the more, and we had to embrace it because of its convenience. A protocol was put in place. African Arbitration Academy Protocol on virtual hearings was put in place, which is supposed to guide us in Africa or even wherever to be able to latch on this online dispute resolution for virtual hearings and get the desired results that we require. And I spoke about after the African Continental Free Trade Area, and how I know that with it, there are going to be a lot of disputes, and the alternative disputes mechanisms are the ones that are going to really be used to settle the disputes across borders. So is it a good thing? Yes, even though I have outlined a bit of the disadvantages that this can bring about, but is it going to be sustainable? Yes. All we need to do is enhance our infrastructure. Make sure you have good internet, make sure you have security, and then you can do whatever you want on the platforms that are available. Thank you.
Thank you, Justina. You have posed a very important aspect of what are the unique procedural challenges that may impact the right of parties in these virtual settings. In fact, the word you coined, Zoom fatigue, is somewhat very interesting, and you're absolutely right. Sooner or later, we all will start feeling that. And in fact, the argument on that if you have not seen the person live, you have not seen those gestures, that definitely has an impact, in fact, on these virtual settings. Karim, how have the judicial forums in the Middle East ensured that such digital litigation still safeguards the rule of law? What has been the impact on accelerated digital litigation mode in the Middle East, and how courts have adapted to digital transformation in the UAE and in Saudi? If you can throw some light there.
Sure. Well, again, going back to the infrastructure readiness and the mindset that comes with a set of measures, like, you know, having the proper regulations in place which govern privacy and security, cybersecurity. So those were already effective and in place. Yes, they get adapted every now and then with how they arise, but with this in place, whether it's the courts, whether it's the venue of dispute, they're using a particular platform, there are regulation that mandates they have to comply, or their supplier or their provider who provides such services comply with particular security controls and cybersecurity controls and measures. So it didn't come from a vacuum. The law was there, the regulation was there, the regulators were there, the terms and conditions for doing such, exploring such transformation is there. So it's a matter of, again, you're complying as you're turning on the switch, on to go into digital litigation mode. You have the ecosystem in place, you have the legislation ecosystem in place, and it's a matter of complying or not. And that's an ongoing monitor as well by the regulators. So it's not a matter of, one hearing went well and then after that, no, there's a continuous monitoring by the regulators to ensure that those providers, that this venue dispute, whether a court or arbitral tribunal appointed by the court, deploy or is working within the parameters of those regulations. So it's a whole pack or a whole stack of technology and legislations and regulations and measures in place to enable this and to sustain this and enable growth as it evolves. Now we know those platforms, but like we used to say in a very long time ago when we're starting intellectual property practice, digitally now known or later developed. That's a term that we are seeing very much of its application now, because you will have different platforms, you will have different modes. And my anticipation or expectation that governments, as they have, went in and put the regulations, they will also put the governing regulations for ADR or ODR. It's not going to be left for the technology provider, it's not going to be left for the litigator. It's going to be directions from the government, from the country, in terms of how they want to take this to the next level. Thank you.
Thank you, Kareem. And I think it's very relevant of putting regulations to ADR and ODR. In fact, we have one question which has been raised by Marshall Borasho, who's asking, and I will put this question to both, open to Kareem and Justina, and if Saeed also want to pitch in. How do we address the reservation against virtual hearings, especially on the constitutional right of the accused to confront the witness against him or her? Justina, this is somewhat similar to you mentioned about the gesture and how you would want to address the situation, but if you can throw some views on that.
Okay. For me, yes. In a ODR setting, like I said earlier, it is not an aggressive way of settling disputes. It is a friendly way. Assuming you were there physically, nobody will allow you, because sometimes you will be taken to rooms where you will stay until they hear one party before they now bring you in and you can talk. Yes, you are allowed to vent in any situation. You are allowed to vent, but there's control, and that is why you have the mediator or the arbitrator to facilitate and to give the borders and to tell you this is exactly where you should start and stop. You are not there to physically attack anyone, as it were. Let me use those words. You are there, you have submitted yourself because you want the disputes resolved. So I think your constitutional rights is not infringed in any way if you have submitted, particularly for the arbitration where you have to have agreed, because usually there's an agreement either in your contract, or if there isn't, you will submit to an agreement to arbitrate. So I think to that extent, no constitutional right can be infringed or breached. I think I'll stop there for someone to continue.
If I may add to Justina here on this, we have to differentiate between criminal or cross-examination in a natural or a commercial dispute. And I believe if we are tackling the angle of criminal or witness. I don't think this will be happening on Zoom, because there are particular rights, must be accorded to the accused. But if we take the commercial, or as Justina put it, we're here to resolve amicably, whether the mediation mode or there are cross-examination online, and it's happened way before the COVID. And as I said, using other modes, whether Zoom or Chimes or Skype, all these, this is accustomed. And I think there's a role for the arbitrator or the mediator here, and it's a bigger role where he has to really govern that virtually. And I think a lot of training has been available for mediators and arbitrators to undergo in order to manage cross-examination or data, disclosure, or cross e-discovery. There are a lot of technology and application that manage this process. So in no way, as Justina said, it could infringe on your constitutional right.
Thank you very much. I think that very effectively addresses the query raised by one of the attendees. So, okay, now let's just switch to the other relevant topic here. And we all agree that the banalities of law are common across jurisdictions. Every legal system grapples with its own peculiar issues. In fact, there have been instances where they unite in consideration of a solitary legal quandary are few and far between. COVID-19 prompted exactly this last year. Everyone in the world who has read law was thinking of just two questions. Is COVID-19 force majeure? If not, what contractual relief can help escape the burden imposed by COVID? Saeed, I invite you to ponder on these questions, and if you can also provide the remedies that contractors can seek under UAE law to get relief from the onerous impact of COVID-19.
Yeah, sure. Thank you, Divya. Actually, let us start under the UAE law. Contractors can definitely seek relief under the force majeure provision. However, as you rightly said, would COVID-19 be admissible by the courts as a force majeure event? So this is a question that I would like, and together we can address it in the subsequent topics of this webinar. However, if you want to concentrate on the other remedies that are available under the UAE law, other from the force majeure provision, I can highlight on some articles in the UAE Civil Code, articles namely 472 and 893, in which the contractor can seek termination of the contract if its performance is prevented or rendered impossible. And such impossibility has to be not attributable to the contractor, should not be induced by the contractor himself. And in such case, the contractor will get paid the cost of the performed works, whatever works he has performed until the impossibility commenced, and as well as any incurred costs resulting from such impossibility. Also, it's worth to mention here that the UAE courts have imposed on the contractor a mitigation obligation, actually, in which he needs to prove that very important here to prove, like in the construction projects, that the contractor has implemented reasonable health and safety measures, such as the social distancing that we talked about before, sterilization and sanitization, wearing masks and isolation of the infected people. So those actually has to be implemented on sites properly in order to ensure that the contractor will not lose his right, or it won't, failure to do mitigation, it will not reduce his entitlement, actually. Also knowing that due to the fact that this is very important in UAE as well as in other GCC countries, and the construction sector was considered as a vital sector, and it was exempted from the governmental lockdown measures and the curfew restrictions. So most of the performance of the construction contracts continued with a very minimal interruptions. And there is no actually long suspensions there. Were only small and temporary suspensions. And therefore the performance impossibility which leads to contract termination as an operation of law, is out of question and cannot be utilized. We cannot seek that relief because unless there is a suspension, and most of the projects, they continue performance actually. So, however, the contractors that were suffering from inordinate delays and excessive losses due to COVID and restrictive measures, they can still seek relief under other provisions of the UAE law, which is Article 287, which actually excuse the contractor from making good his obligation. So it will excuse him to recover the delays that are caused by an external factor. So this will provide, this article can provide the contractor and can grant him an extension of time, but does not address the compensation of the incurred cost due to COVID-19 and restrictive measures. Moreover, actually, there is a very important notion and principle under the UAE law, which is called the principle of exceptional circumstances, which is similar to the doctrine of imprevision under the French law. And that's what differentiates the civil law countries from the Commonwealth countries. So knowing that the reaction of the courts in UAE was not encouraging during the global financial crisis in 2008, and they considered, as an example, inflation and recession as normal risks of business, which can occur frequently and could be envisaged by the developers and the contractors. I can say that the same UAE courts now are taking more flexible approach during COVID, where in a recent case, the judge had not allowed a lessee to terminate a lease agreement for a gym, but he permitted him not to pay the rental fees during the lockdown time. So having said that, there are certain also conditions, which is very important to highlight on for the courts to consider an exceptional event as, or a unforeseeable event as exceptional event under this relief of the Article 249. The first of it is non-foreseeability. So the event should be unforeseeable and different from the circumstances which were existing at the time of concluding the contract. So as an example, if a contract is entered now, it can be argued that the risk of COVID-19 is foreseeable. And this is always a risk. Also, the occurrence of COVID-19 is debatable whether it has started or it occurred in December 2019 when it started in China, or in March 2020 when it was declared as pandemic by WHO, or at the time when the restrictive measures were imposed by the authorities. This is another challenge also for the foreseeability. The second condition is a public nature test. So the event would be, should be of a public nature. But in this case, COVID-19 will pass that test because it's declared as a pandemic by WHO and communicable disease by UAE authorities. However, and moreover, the governmental measures such as the suspension of flights and visas and closure of borders, they affected a wide range of people in UAE. The third condition is unavoidability. So the event cannot be avoided and or prevented in order to benefit from that relief, by definitely exerting reasonable measures. So if COVID-19 occurred during, and this is a very important point, if COVID occurred during a period beyond the contractual duration in which such delays are attributable to the contractor, then it can be argued that if contractor finishes the work on time, he could have avoided the impact of COVID. So this means that he should not benefit from the relief if he's inducing the delay himself. Also, the contractor who suffers delayed deliveries of the imported supplies due to lockdown in the manufacturer's country shall have an obligation to explore for other alternatives in other countries in order for him to benefit or to prove that he has done his reasonable endeavors to avoid the impact of COVID. The fourth condition, which is the last, it is grave loss. So the impact of COVID-19 and the restrictive measures should be severely onerous and leading to grave losses on the contractor. Otherwise, the contract cannot invoke this remedy. Now, if COVID-19 or the restrictive measure pass those tests, which is very narrow actually, and we have seen during the financial crisis in 2008, it was not successful by the contractors and developers to seek relief under exceptional events. However, we have seen one case here during COVID for the lease of a gym. So of those, if COVID-19 and the restrictive measures, they pass that tests actually, then definitely the judge will interfere. The relief that we will bring to the contractors is that the judge will interfere to bring balance back to the contract by sharing the incurred costs between the parties, and he can grant them also extension of time. Yeah, thank you.
Thank you, Saeed. I think you've well put the issue arising out of all these contractual parameters and how force majeure event has been perceived in your jurisdiction. In fact, I would also want to throw some light from my jurisdiction. And as you rightly said, that force majeure is an event or an effect that can neither be anticipated nor controlled. It is usually, it in fact includes both acts of nature and acts of people. So the act of God per se is one of the issues which my jurisdiction, India, has grappled with. In fact, the contracts often contain force majeure clause that is negotiated between the parties and specifies the events that qualify as force majeure event, such as act of God, war, terrorism, riot, labor strikes, act of government, epidemics, pandemics, plagues, etc. But in India, they've been reluctant to lay down a straitjacket precedent declaring COVID as a force majeure event. In fact, there was an argument to that effect that one of the Supreme Court decision held that the expression act of God signifies the operation of natural forces free from human intervention, with the caveat that every unexpected natural event does not operate as an excuse from liability if there is a reasonable possibility of anticipating that happening. While we all agree that COVID was absolutely unanticipated, it's not something which is in anybody's control, but largely it has been governed by the fact that whether your contractual obligations are such that they can actually cover such kind of an act or an unnatural act for that matter. If not, then too bad, you have in fact missed the opportunity. Now that we have considered the impact of COVID on contracts and conflict resolution, only one concern remains. How will COVID change the substance of commercial disputes? Are there any fresh considerations parties must be aware of? I'd like Kareem to throw some light on how COVID-19 has reshaped force majeure disputes.
Well, for a starter, a due diligent review of the force majeure clause. I mean, we've all know that force majeure is a key component of the contract to render its enforceability in court, make it enforceable. However, I'm sure since for a while, I mean, people would review the force majeure clause lightly or as a standard practice. Having specialized in telecom infrastructure and technology, force majeure is something that's been always reviewed thoroughly by the parties, because you have different format like outage, cable cuts, internet blackout, stuff that are not acts of nature in a way, but it is it has an impact on the performance, okay, and can qualify. So for a starter, I'm seeing now a lot of force majeure clause include the word pandemic, but like we correctly said, the forum here mentioned that the pandemic in itself may not be viewed as a force majeure event. Rather, the government restrictions resulting from that. For example, in Saudi, there was a full lockdown. There was a full shutdown. So even though supplier wants to move, the government have restricted them. And actually, so you can't argue here that pandemic is the force majeure, it's rather the government restriction. And that's very important to segregate why you're composing your force majeure claim. There's also other components for the parties to consider, whether your outstanding payment was due before the force majeure event or not. Okay, because if it's not, then there's negligence on your part, and you can't claim. Maybe the force majeure will delay further, but why you were late? So there are so many things that we would you know, a lot of business took lightly or have not put a particular mechanism to manage it, you know. And with the pandemic and the COVID and the lockdown and all the changes that happened from March 2020 until now, people are more meticulous on, you know, the consequence of a force majeure event. How can we manage it on the interim amicably, where ADR comes in here very key, because usually the force majeure event, people say, okay, we're resetting the contract, we're suspending, we're not going to perform. But people now realized in the COVID, they need to work together, okay? And to be honest, sometimes some parties have realized that it's a good break to revisit the contract, to revisit the operation of the contract, what needs to be improved, because sometimes parties claim or say, you know, a contract signed, halas, we're not going to look into the contract. But, you know, those events have invited us to continuously monitor the operation of our contract performance. So it added a lot on lawyers, business decision makers, okay, to meticulously measure and assess the consequence arising from a force majeure. And that's a big plus for across the board. Thank you.
Thank you, Karim. You're absolutely right there that there are consequences to it, and you need to be smart enough to appreciate that how to draft the contract clauses. Thanks for throwing a bone for the arbitral lawyers like us. Anyways, so we have a couple of questions which I want the panelists to address. Since we are still on the issue of force majeure, Saeed, there is a question for you from Mr. Nitesh Sathi. His question is, as force majeure is excusable and not compensable, what if force majeure sustained for more than 100 days? What remedy do the contractors have to recover additional cost incurred during force majeure?
Okay, if I understand the question properly, if the force majeure is excusable but not compensable, so it can grant the extension of time, but it will not compensate the contractor for his incurred costs. And there is a prolonged suspension in that way. So it prolonged for more than 100 days as a force majeure if it's causing suspension something, and if it's causing delays and disruption something else. So if it's, and it depends at the end how the contract is drafted. If I talk from our experience in UAE, most of the contracts are influenced or are FIDIC based actually, the standard contracts, which is somehow it's the same standard contract or modified by the clients or by the governmental companies. They, as you rightly said, they excuse the delay, but or they will provide extension of time, but they will not compensate the costs. Under the FIDIC itself, if you want to seek the relief from the force majeure provision, if there is a delays and disruption, it is very challenging to go into that aspect. You have to look into the extension of time under clause 8.3 or the change in law if you want to get compensated for the cost under clause 13.7. However, again, also you have to prove that the restrictive measures. Why, as Karim rightly said also, because the impact of the delays and the disruption on the progress is not due to COVID-19 itself. It's not a direct result of the force majeure itself. It's a result of the restrictive measures. So we have to look into if those restrictive measures are considered under that jurisdiction as a change in law. As per FIDIC, the law allow the regulations and the bylaws and the municipalities, but even though under UAE law, there is a law for the communicable disease, and COVID was declared as a communicable disease. The second part is that if there is a prolonged suspension under force majeure, then the FIDIC itself, there is 84 days, I think, and continuous 84 days, and in aggregate, I forgot the numbers, we can seek termination. Whenever there is termination, then definitely you can get the value of the performed works, as well as you will be compensated for all the incurred costs arising out of the termination. Thank you.
Thank you. Thank you. That very well answers the point. There are a few more questions, and I would have to now jump back to the first topic on ADR. And this question will be for Justina. Justina, what are the prospects for genuine cross-border ADR forums other than commercial ones? This question is from Alan Asher. Though I believe you have alluded to it, you have given the other forms of cross-border ADR forums, but maybe for our audience, just if you can repeat that.
Okay. I mentioned that there were negotiations. There's another one that is conciliation. There's also mini trial, or mixture of the different settlement mechanisms. But I said for the purpose of our webinar that we will concentrate on arbitration and mediation. Now, it all depends on what the parties want, or when the mediator or the arbitrator, as it were, evaluates. If they evaluate the disputes and it's such that it could be a mixture of mediation and arbitration, the mediator or the arbitrator will advise such. So if you start a process, for instance, with mediation, it can end up with arbitration. So, I mean, there's no particular way, except if the parties say they are dissatisfied, then you could start to mix and match or find a means, since parties are willing to settle. The key thing there is the parties are the ones that drive their own process. Like I said earlier, the mediator just facilitates a settlement, guiding the parties. So, I mean, there's no straightforward answer to the question, but the dispute and the parties would direct or give the inclinations as to what method will be best suited to resolve their dispute. Thank you.
And I echo that sentiment that there is no straitjacket formula there. It will definitely depend on how the contract is there, what is the, in fact, sometimes even what is the complexity of the issue involved is also another relevant factor that comes into play. Now let's come to another question, and I'm sure this question even Saeed would agree to. How can arbitration be made less expensive? This is a question from Mumtaz Bhalla. The question is, how can arbitration be made less expensive? I would first start with Kareem. If you can give some view on that, then maybe Justina and I can pitch in.
Well, it depends on the seat of arbitration that you will choose. That's number one, okay? It depends on the complexity of the dispute and the number of experts that you will anticipate to bring in on that particular contentious point or points. You may have more than one expert. So reducing the cost is utterly up to the parties, to be honest. And the longer the dispute, the higher the expense. So this is a very difficult question to answer. But again, choose a venue of arbitration, minimize the arbitrator numbers, choose it close to home so you avoid traveling across and, you know, or across the Atlantic sometimes. Avoid, you know, try to resolve technical matters ahead of the formal arbitration to minimize expert intervention. So there are a lot of modes, but it is very difficult if it's a complex and large arbitration, which is usually the key. And that's why we choose arbitration sometimes, because you need experts that are not available in the court, okay, particularly in technology or telecom or, you know, particular segments. So again, it depends on the parties.
I agree. And in fact, the theme of our today's discussion also is another point which helps in reducing costs, which is to shift virtual mode, go for a virtual platform. That would definitely, as I said, save a lot of cost in traveling, accommodation, those carbon footprint, the environment. It's good in that respect. Maybe Justina, one thought from you, and I would also like Saeed to give the perspective from a client's side as to how he feels that the cost can be reduced.
Okay, from me, I agree totally with Karim and yourself. I was going to advocate that now we have online dispute resolution and we can have virtual hearings. So the issues of tickets, accommodation are all out of it. So all the person needs to contend with is the data or the internet that he will provide, and probably maybe the device that he will use wherever he is. So that alone has reduced the cost drastically. Nobody, he has the option to choose virtual hearing, exactly. And the protocols are provided for it, how it should be guided. So I think that legislation has helped to reduce the cost for, for arbitration or mediation. And therefore, I think that it is a welcome development. And like Karim said, you don't have to have 3 arbitrators, for instance, and then your seat of arbitration, choose Africa, it's cheap. Don't choose UK, London, or Singapore that are the most
Same
popular.
goes for India.
So you can choose Africa and it will be cheap. Thank you.
Thank you.
Yeah, so I would like to add, Divya, as you rightly said, and as Karim and Justina also said, I would like to add about the importance of dispute avoidance before you reach arbitration, which is actually neglected most of the time in the contracts, and it's a mechanism or a structure that's already available under the FIDIC standard contracts, like the Dispute Adjudication Board or the Dispute Adjudication and Avoidance Board. So if you can establish that board at the beginning of complex projects that are longing for 4 and 5 years with a lot of disputes, a lot of technical matters, and every disputes, instead of wait and see and leave it till the end until all the experts will leave the project, and then nobody can resolve it unless you go to arbitration. If that board is in place, then it will reduce the cost on everybody. However, if it's inevitable to go to arbitration, I can feel on top of whatever you all said, and it's all correct and rightly said. I believe also you have to select the right arbitrator from a technical perspective. So nowadays there's a lot of successful engineers that are acting as arbitrators also, who has also the background in law, and they can add a lot in order to resolve the arbitration in a very fast way. And that's, I think, is adding a lot actually for reducing the cost on the arbitration. Yeah.
Yeah, thank you. That's quite relevant there. Then I'll just quickly take the next 1 or 2 questions. They seem to be quite straightforward. If arbitration clause is silent in agreement, can the parties approach court? I would say that's the straightforward answer, yes, because if your agreement does not, arbitration is a creature of contract. If it is not provided there, too bad. You have to go by the regular mechanism. I believe everyone on the panel would agree to that. Then the next question is, why not all the commercial disputes be first refer to ADR instead of judicial litigation for speedy, effective redressal? This is a question from Baldev Sachdeva. I'll just quickly suggest one line there and open the floor for anyone to add. At least in India, there is now effective measures passed by the legislature that before you litigate in a suit, you should conciliate, you should make an attempt to conciliate with the parties, and the courts are providing for those conciliation mechanisms within the court premises. There are centers to that effect. I would request if any other panelists would like to add anything to that.
I would like to add, Divya, you're absolutely correct. I'll give you an example now of intellectual property disputes in Egypt, for example. Okay, they've matured and been nurtured for a while, so they've moved into the economic court for speedy. process, but also they would require, okay, the parties, before they go into the litigation mode, that they exercise, reconciliation and mediation sessions of 5 sessions, 8 sessions. But there is a direction from all around that, try to resolve it amicably before you jump in and get into the bureaucracy or all the formalities. So that is a very important trend we see court now are undertaking in Egypt, in the UAE. It was very popular in marriage and divorce that the court would direct the parties to reconciliate first before, and we're seeing that being brought into intellectual property dispute, technology disputes, things related.
Yeah, thanks, Karim. In fact, yeah, sorry, please.
I would also like to chip in. In Nigeria, we have, particularly in Lagos State, we have what is called the pretrial conference in court. So at that stage, the case is evaluated and looked at. And if it is one that is best suited for mediation, the court refers it to Lagos Multi-Door Courthouse for mediation. But where that fails, then they can return to court. So just like deviance that is happening in India is also happening here in Nigeria. So not everything is heard by the court, because the courts are inundated with a lot of cases. So the ones that can easily be settled out of court, they refer it to the Lagos Multi-Door Courthouse. So we have some of those multi-door courthouses in some jurisdiction in Nigeria. Thank you.
Thank you, Justina. There is a follow-up question that if the agreement mentions resolution through arbitration, but the process is not well defined, can the parties approach court? Karim, Saeed, anyone would want to take that?
But yeah, the arbitration agreement has to be valid. But if it's very clear that both parties, they agree to go to arbitration, actually, they can agree on all the procedures later on. The most important thing is to agree on the seat and the arbitration law, in my view. So it will guide them for everything else. Maybe Karim and Justina can add more about this.
Sure. As you correctly said, Saeed, the arbitration clause must be called out explicitly in the contract. And rarely that we see a clause saying the parties agree on arbitration full stop. They usually set forth, in bullet points, even in the least unsophisticated form. They just say, okay, the seat would be, in India, in Africa, in Dubai, 2 arbitrators, 1 arbitrators, and the party, the arbitration is not appealable, whatever. But there is a standard that everybody uses, and it's very rare that we see the parties are silent on the mechanism. And but if they are silent on the mechanism, that I think it's a problem, because that's another dispute. That will definitely another dispute arise.
That's absolutely correct. That is it, because there are standard clauses for drafting these arbitration clause. So if they are silent on the mechanism to use, then it means that is a dispute in itself. So it must be specific, which means then that the drafter of that contract is not on top of it, or has created a dispute for the parties by an irregular drafting. So I think
yeah,
there's an agreement,
right,
to be properly, yes, drafted.
Yeah, you're right. In fact, even what is important is that even as Saeed rightly said, that if you have the seat in place, and let's say the clause doesn't say anything further, then at least that local jurisdictional arbitration law can come into place and fill that gap of what the process needs to be followed.
If I would like to add also, like in UAE, they are very keen that arbitration is an alternative dispute resolution. So it's an alternative to the constitutional rights of the parties to go to and approach the courts. So if the arbitration agreement is not properly drafted, most probably it will lack jurisdiction. Most of the cases, arbitration will lack jurisdiction unless there is a legal intention and a clear intention by both parties that they opted to go to arbitration as per the arbitration rules.
Right. Thank you.
But
So
I think that just a minute.
Yeah,
I think that where it is also not properly drafted, you know, they can submit, they can do a proper one and submit themselves to arbitration where it will properly be drafted, and then they can carry on. So you make use of what is called a submission agreement.
Right. That's right. Thank you. So we are left with 3 questions. With time is almost up, but I'll take them very, very quickly. Let's see if we can answer them shortly. So first question is how to avoid negotiation mistakes that may turn counterproductive if the case is to be litigated due to failure of negotiation. It's a big topic to address, but anyone would like to just quickly answer that?
Sure. I mean, by taking the dispute resolution clause first very seriously, okay, and identifying the underlying common interest of it rather than visiting the scope of the contract again or increasing it or negotiating the price again. I mean, if you follow, and honestly, those dispute resolution, you know, we call them ombudsmen sometimes, if they are carefully followed during the process, like, you know, approaching the correct, you know, referenced authority there, whether it's a C level that you need to approach, whether you're sending the proper notification, whether you're sending the correct specific incident that you're disputing and the supporting facts. If that process is followed carefully and seriously, and the parties really want to wish a dispute on an agreement on the milestone deliverable, for example, or the acceptance of that milestone, okay? If the process of dispute is followed carefully with the intention of resolving it amicably and moving forward, then this negotiation will succeed. But if it's not, and it's only, you know, a matter, and there are always indication and there are always signs, okay? If this intention is to really resolve it or prolong or there, sorry, yeah.
Thank you. That's absolutely correct. I'll just quickly jump to the last 2 questions. What is the difference between seat and venue in arbitration? I'll just straight away answer this. Seat is the juridical seat from which the arbitration is supposed to be completed, the award is to be passed. That's the seat that will take care of your court proceedings as well. Venue is something which parties can choose differently from the seat. And again, it's a whole lobby of discussion there, which we can take it on some other day. Last question is there, and I'll see if Saeed can maybe chip in on that. If contractor failed to achieve completion date, would delay caused by pandemic encountered? I mean, the question, it's from Ahab Musa. Yeah.
Can you say again, please? If contractor delayed completion date, I didn't hear the completion of the question.
Yes, it says if contractor failed to achieve completion date, would delay caused by pandemic encountered? I think the question is not complete. I maybe completed that. Will the delay caused by pandemic, would that be excluded from the completion date failure, which the contractor is not able to achieve?
Yeah, I have addressed this in my actual topic. Discussing that. So under law, it will act against the contractor definitely, because it's similarly, as an example, if you cannot claim interest charges, as an example, during the contract duration, and now you have delayed, or you cannot claim escalation of prices for the steel, as an example, the steel is increasing. And now the contract duration has lapsed and you have delayed, and it's because of you have delayed the project. The other party can claim for such kind of escalation. Similarly, if you are into breach or into negligence and you have delayed the contract duration and the completion date of the works, if the COVID-19 will come, it will reduce your entitlement. And in most cases, it will be considered as a concurrent delay also, and concurrent delay is a very controversial topic and a debatable thing that requires all of it a long webinar to discuss it also.
Thank you, Saeed. We have managed to answer all the questions. What an efficient panel we are. We have completed it exactly 1.5 hours, which was allotted to us. So over to the ClickAway team, Bharti.
Thank you so much, Justina, Divyam, Kareem, and Said for sharing such great insights and for a wonderful session. We still have a couple of questions that we were not able to put in the question box because of the time limit. And I'm really sorry to the audience who had dropped the questions, but we were not able to answer them. We'll make sure to make it up to you. Also, it was a pleasure to have you on board with us. A big thank you to all the speakers yet again, and not to forget people who took out time to be a part of this session in our audience. A recorded version of this web conference will also be uploaded and the link will be shared without fail. This is Bharti for Lex Talk signing off, and thank you so much once again.
Thank you very much. Have a wonderful day. Thank you, everyone.